Picture this: a single Supreme Court decision that could reshape the U.S. Congress, handing Republicans a lasting edge in the House of Representatives and potentially sidelining minority voices for decades. It's a high-stakes drama unfolding right now in the world of voting rights, and if you're wondering how our democracy hangs in the balance, stick with me. This story reveals just how vulnerable our electoral maps truly are. Back in March, passionate protesters gathered outside the Supreme Court in Washington, D.C., waving signs to champion minority voting rights. Their message was clear: protect the power of every voice in our elections. Fast forward to today, and a pivotal case is back before the justices on Wednesday. One that doesn't just threaten the heart of the Federal Voting Rights Act, but could open the floodgates for Republicans to redraw congressional districts in ways that boost their seats dramatically. At the center of it all is Section 2 of the Voting Rights Act, a crucial safeguard enacted decades ago to prevent racial discrimination in voting practices. Think of it like this: it ensures that states can't draw district lines in a way that dilutes the voting strength of racial minorities, giving them a fair shot at electing representatives who truly reflect their communities. If the court strikes down or weakens this section, experts warn, Republican-led states could seize the opportunity to create at least 19 additional House districts tilted toward GOP candidates. That's according to a fresh analysis from advocacy organizations like the Black Voters Matter Fund and Fair Fight Action. You can dive into their detailed report for the nitty-gritty numbers and state-by-state breakdowns. And timing is everything here. The case, officially titled Louisiana versus Callais, might wrap up with a ruling that allows some of these changes to take effect before the 2026 midterm elections, shaking up the political landscape just when it matters most. But here's where it gets really intriguing. President Trump's administration is already fueling a Republican drive to craft new maps in key battlegrounds like Texas, Missouri, and North Carolina. These efforts aim to lock in the party's narrow House majority heading into the next cycle, and a favorable court decision could supercharge that momentum by removing long-standing barriers against diluting minority voting power. Supporters of the Voting Rights Act are on edge, especially after the conservative-leaning court punted on this Louisiana dispute last term. Instead of deciding, they called for unusual second oral arguments, zeroing in on whether Section 2's rules for redistricting hold up under the Constitution. For those new to this, redistricting is basically the process of redrawing electoral district boundaries every decade after the census. But mid-decade tweaks, like what's happening now, can be a wild card in tight races. The ripple effects could be massive, particularly in the South, where Republicans often hold the reins of state legislatures and governorships. In places with stark racial voting patterns, where black voters overwhelmingly back Democrats and white voters lean Republican, weakening Section 2 might mean mapmakers no longer have to create districts where minorities can realistically win elections. States like Louisiana, Florida, Georgia, Missouri, North Carolina, and Texas could see a drop in Democratic lawmakers as a result. Even worse, Alabama, Mississippi, South Carolina, and Tennessee might end up with 0 Democratic representatives at all, per the report's findings. That's not just numbers on a page. It could wipe out up to 30% of the Congressional Black Caucus and 11% of the Congressional Hispanic Caucus, eroding diverse leadership in Washington. Cliff Albright, co-founder and executive director of the Black Voters Matter Fund, puts it starkly. This could solidify Republican dominance in the House for a generation or more. We're highlighting in this report that the South's challenges don't stay confined there, he explains. Racial gerrymandering. That's when districts are drawn to unfairly advantage one racial group. Doesn't just silence Black and Latino voters or boot out elected officials of color. It echoes across the nation, affecting policies from healthcare to civil rights for everyone. And this is the part most people miss. These maps influence everything from national legislation to your local community's funding. Let's break down the Louisiana case a bit more to make it crystal clear. A federal lower court stepped in after black voters sued, compelling the state's GOP-dominated legislature to craft a new congressional map that complied with Section 2. This updated map was used for the 2024 elections and helped Democrats snag an extra seat in Louisiana. A real win for fair representation. Alana Odoms, executive director of the ACLU of Louisiana, whose team is supporting the plaintiffs, emphasizes its importance. Section 2 guarantees that communities of color get an equal say in elections and can choose leaders who champion their needs. Without it, we risk losing the core of democracy, true equality and opportunity for all. Imagine if your neighborhood's votes were systematically weakened. That's the fear here. But here's where it gets controversial. Opponents, including a coalition of voters led by Philip Callais, who identify as non-African American, claim that requiring race-conscious districting to meet Section 2 standards is itself unconstitutional. They draw parallels to the court's 2023 smackdown on race-based affirmative action in higher education, arguing it's time to ban race from political map drawing altogether. The Supreme Court even posed a pointed question in granting rehearing. Does deliberately creating a second majority-minority district in Louisiana breach the 14th or 15th Amendments, which protect equal protection and voting rights? In their recent filings, Louisiana's Republican officials are pushing hard against any role for race in redistricting. No exceptions. Shockingly, the Trump-era Justice Department has flipped the script from previous administrations, now asserting that Section 2's anti-discrimination measures are outdated and unconstitutional. 2 years back, the court shot down a similar challenge from Alabama Republicans in the Allen versus Milligan case, upholding the act. But, as Atiba Ellis, a law professor and associate dean at Case Western Reserve University notes, the justices might reaffirm that protection again. Yet, like many watchers, I'm worried the court is growing skeptical of race-aware solutions to deep-rooted civil rights issues. This could be the breaking point, where they gut Congress's power to foster a multiracial democracy. Ellis warns that amid the fierce partisan tug-of-war over mid-decade redistricting, such a ruling, combined with the 2019 decision that partisan gerrymandering isn't federally challengeable, could unleash chaos. Politicians from both parties already play hardball with power, he says. Section 2 has been the vital guardrail against racial bias. Without it, the fallout could reshape our politics for generations. For example, in a state like Georgia, where voting divides along racial lines, unchecked redrawing might pack Democratic-leaning minority voters into fewer districts, amplifying Republican wins elsewhere. The clock is ticking as state deadlines loom for finalizing maps before the midterms. Louisiana's Secretary of State, Nancy Landry, has urged the court to decide by early January 2026 to keep things on track. However, with the justices typically dropping big rulings in June, uncertainty reigns. Adding fuel to the fire, the court will soon weigh whether to hear a North Dakota case questioning if private citizens and groups, the primary enforcers of Section 2 through lawsuits, can keep filing suits. Mississippi Republicans are echoing that in their own appeal, potentially closing off another enforcement avenue. This isn't just legal jargon, it's about who gets heard in our government. Boldly put, if Section 2 falls, we're looking at a redistricting free-for-all that favors one party and marginalizes others. A controversial shift that some hail as colorblind fairness, while critics decry it as a step back to Jim Crow-era tactics. What's your take? Do you believe race should ever factor into drawing districts to ensure fair representation, or is that reverse discrimination? Could this really lock in one-party rule, or is it overblown? Drop your thoughts in the comments. Let's spark a real conversation on protecting our democracy.